Atwood, for the record, I'm the Professional Standards Division Director here at DPSST. Our chair, Mike Fletcher, is not available for today's applicant review committee, so I will be doing the chairing responsibilities, but obviously not as a voting member of any kind, just kind of keeping the meeting flowing. Before we begin, I'm going to call this meeting to order. It is September 24th, 2025, and it is 11:14 a.m. We are here at the Department of Public Safety Standards and Training. We have several voting members present via Teams remotely. I am going to begin by reading our administrative announcement. This is a public meeting subject to the Public Meetings Law, and it will be recorded. Deliberation of issues will only be conducted by applicant review committee members unless permitted by the chair. Individuals who engage in disruptive behavior that impedes official business will be asked to stop being disruptive or leave the meeting. Additional measures may be taken to have disruptive individuals removed if their continued presence poses a safety risk to the other persons in the room or makes it impossible to continue the meeting. That brings us to our agenda items, beginning with introductions. Starting with our committee members. Let's do a roll call and introductions, please.
When I call on you, please state your name and who you represent for the record. We'll commence with you, Member Boren.
I'm Mark Boren, representing the Correction Policy Committee as a public member.
Thank you. Member Dresser.
Kevin Dresser, a non-management member.
Member Griffin.
Rhonda Griffin, representing APCO-NENA, the TPC committee.
Member Wood.
Robert Wood, represent the PPC as a public member.
And now for staff introductions, Juan Lopez, Executive Assistant, DPSST.
Eric Riddell, Criminal Justice Support Specialist, DPSST. Cindy Park, DPSST. Marie Atwood, DPSST.
Leslie Basho, DPSST. Jennifer Howell, DPSST.
Ben Hamilton, DPSST.
All right, I think that rounds out our introductions. I'd like to give a special shout out to Member Dresser for hopping on the meeting at the last minute. Thank you so much for allowing us to reach quorum today so that we can get through the various agenda items we have left. Agenda item number 2 is approval of the July 23rd, 2025 meeting minutes. Has everyone had a chance to review the meeting minutes from the previous meeting? Those of you online, just give me a thumbs up if you've had a chance to take a look at that. All right, great. I see 3 thumbs up. And as far as our approval of the minutes, all we need is a consensus on that approval. So again, thumbs up if you approve of the July 23rd meeting minutes, or any comments to those. We'd be happy to hear it now. Okay, I see more thumbs up. That will do it for our approval of the July 23rd meeting minutes. We do have one case to present today. I have Cindy Park seated next to me to present the information on that case. I believe Mr. Rios is present today, so if someone wants to go grab him from the lobby, we will bring him in so that he can present his mitigation to the committee. Please. Good morning, Mr. Rios.
Morning.
My name is Marie Atwood. I am the Professional Standards Division Director here at DPSST. Before we begin with your mitigation process, I just want to let you know what that procedure will look like. So first thing that will happen is our case manager, Cindy Park, is going to present the case to the committee. You will then have 5 minutes and 5 minutes exactly to present your mitigation. We have a clock that'll start running when your time begins. If we're getting close to maybe the minute mark, we might remind you that there's 1 minute on the clock. I can kind of signal you for that. Looks like you have someone here as your support representative. Can you identify yourself for the record?
Yes, ma'am. Sergeant Jeffrey Hernandez. I'm the Special Functions and Training Sergeant in Oregon State Penitentiary for Department of Corrections.
Thank you so much for being here today. So aside from the 5 minute time limitation, just so that you're aware, there isn't going to be any questions asked of you, and you won't get a chance to ask any questions of Cindy or the committee as the case is being presented. Do you understand those procedures?
Yes.
Okay. With that, I'm going to turn it over to Ms. Park so she can present the case to the committee.
Good morning, Cindy Park for the record. We're reviewing an application for training and criminal history reporting form for Juan Rios, in which he disclosed previous criminal dispositions. The dispositions occurred prior to his employment as a corrections officer. On November 19th, 2015, Rios pled guilty to driving under the influence of intoxicants and entered into a DUI diversion program. On December 17th, 2015, Rios pled no contest to the offense of reckless driving, a misdemeanor. Both charges were from an incident that occurred on October 21st, 2015 in Salem, Oregon. The second incident is on May 30th, 2018. Rios entered into a friendship agreement deferral program in the Thurston County, Washington Superior Court for the offenses of assault in the third degree, a Class C felony, resisting arrest, a misdemeanor, and malicious mischief in the third degree, a gross misdemeanor. Rios completed the friendship diversion agreement and all charges were dismissed. Moral fitness violations. The department found that Rios violated the board's pre-employment moral fitness standard for gross misconduct when he chose to drive a motor vehicle on a public roadway while under the influence of alcohol and wrecked his car by hitting an electrical box and a fire hydrant, causing damage to property and putting himself and others at risk of harm. Additionally, Rios violated the board's pre-employment moral fitness standard for gross misconduct when he engaged in reckless conduct that caused damage to the lobby of a hotel and while resisting arrest, caused harm to a police officer by straining his wrist. The department did not identify sufficient evidence to support a finding of dishonesty. Director Atwood.
Thank you. So as far as proceeding with the rest of the process, before we start the timer, I just want to make you situationally aware. Most of our committee members are present virtually via Teams, so the speaker in front of you is going to capture what you say, but just be cognizant of speaking clearly and projecting so that the speaker can pick that up. We do have one member present in person today. That said, only the members of the committee will deliberate on your case. So none of us are going to be making any comments or adding to that discussion at all, just so that you know, we're here for the department.
Yep.
Okay, are you ready?
Yep.
You may begin.
All right, well, good morning, DPSST staff. I do understand the request for a hearing today. I would like to take the time to further discuss these issues and hopefully clear any concerns for my continued employment with Oregon Department of Corrections. As stated, my name is Juan Rios. I'm currently a corrections officer with the Oregon State Penitentiary. My DPSST number is 66172. I know I've made mistakes in the past. Both these issues, as stated, were fully disclosed with Oregon State Penitentiary before continuing application with them. Before I even signed any paperwork, giving them permission to look into it, I fully disclosed both incidences, everything that I was able to receive to Laura Mraz, who's the hiring personnel. So she had everything before she even received it from either facility with Oregon or Washington. Yes, I did get a DUI. I fully admitted guilt to it, took responsibility for my actions. Didn't try to talk my way out of it. Took on the diversion program, stayed in constant contact with my attorney. So once everything was completed, both the courts and judge was fully aware of my steps, my progress. Completed that on December 17th, 2015. Unfortunately, yes, the second time, October 4th of 2017, I did find myself in another alcohol-related incident. Still now, after 8 years of reading back on those reports, still kind of upset me on how I conducted myself, and how I presented who I don't want to be. But since those timeframes, I've had my daughter and took a lot of time reflecting on how I've been, how I am as a role model to her. And so I've taken the time to change my actions, change the person I want to be for her, and continued myself pushing forward, making a better role model for her and those around me. I've also presented statements from my current employer, my previous employer, showing the steps I've made to be a better person for her, along with the peers around me. And so I hope that that's been something that stands out with how I've been in beforehand and not how I want to be now going forward. So I thank you for your time to let me make my statement here today and go forward from here.
Okay, anything else, Mr. Rios?
No.
Okay, thank you for presenting the testimony to the committee today. The next step is for the committee members to adopt or choose not to adopt the record as has been presented. So all of the committee members are in receipt of the meeting materials, which include Ms. Park's staff report and any records that were compiled by the department. And now they are in receipt of your mitigating testimony from today. So committee members online and present, are we at consensus to adopt the record as has been presented to the committee? Please, if you're online, show by way of thumbs up whether you're in support of adopting the record as presented. Okay, I see full consensus to adopt the record. Are there any objections to the record? Okay, I see no comment in response to that question, so the record will be adopted. Now is the time for the committee to discuss any aggravating and or mitigating factors. So I will open the floor to committee members to discuss and deliberate on those factors at this time.
Rob Wood for the record. I'll start with mitigating. First of all, I appreciate that Mr. Rios is taking full responsibility. I also appreciate, I think I counted 4 or 5 letters of support post these incidents. And the fact that his current employer was well aware of the charges and has taken a risk knowing these, I think that speaks to supporting Mr. Rios. And the fact that he came in person today and as verbally, they said once again, he's taking full responsibility.
Kevin Dresser for the record. I think all these aggregating factors are, concerning with regard to the incident at the Great Wolf Lodge with regard to the intoxication, his behavior. That's concerning both these alcohol-related incidents, but I do look at the time has passed since those incidents. So mitigating, him being here today, taking responsibilities, the letter of support, his employment with Department of Corrections, and I think there was some sincerity with regard to his comments of changing his ways and not going back and making the same mistakes with regard to the raising and responsibility for his daughter. So those are my thoughts based on my review of the record and his testimony today.
Robert, for the record, now I'm going to talk about aggravating. That Kevin did cover some things. I think we have some very concerning behavior during interaction with law enforcement, and these were both alcohol related, but both of them became very aggravated, with the first one refusing to get out of the vehicle, I believe, and refusing field sobriety, with that's his rights. But the second one was very concerning, how the alcohol affected him, with urinating in the lobby, having to be tased twice. I think these are things that we just need to recognize as committee members, as in my opinion, very concerning behavior. Including kicking, I think there was kicking of the patrol car where I think they had to hog tie them, I can't remember. They did, they hog tied him to prevent further damage to himself or the patrol car.
Committee Member Dresser, again, for the record, I agree with Mr. Wood. That was very concerning. My part, specifically the second incident with urinating in the public view of children and families at that lodge, and then the amount of force necessary to detain him and arrest him eventually was very concerning. So I agree with those aggravating factors, very concerning. This is well beyond, I think, not to say a DUI isn't a big deal, but this is more than a simple DUI, especially the second incident.
This is Marie Atwood for the record. Any additional discussion of aggravating or mitigating factors from any committee members? That concludes our discussion. I will ask Ms. Park to recount the aggravating and mitigating factors that have been presented so far.
Cindy Park for the record. I recorded for aggravating the incident at Greenville Lodge was concerning regarding the intoxication and his behavior, such as urinating in public in front of children. Both incidents are alcohol related. The concerning behavior regarding his behavior towards law enforcement, leading to being tased and hogtied to protect himself in the patrol car. I think I combined a few of those. Did I miss anything from the committee on aggravating? Mitigating, Mr. Rios has taken full responsibility for his actions. He provided letters of support, and those were post incidents. His current employer is aware of the charges and has employed him. He came in person today to provide verbal mitigation and appears to be sincere in his comments made in verbal mitigation towards his behavior with his family and wanting to make positive changes and be a positive influence. That's what I have.
Okay. Now that those aggravating and mitigating factors have been recounted for the record, this is Marie Atwood, by the way, we need to see if the committee offers again a consensus to the identified factors as have been presented by Ms. Park. So by way of a thumbs up, do we have a consensus on the aggravating and mitigating factors? Okay, I see a unanimous consensus there. At this point, the committee now should discuss any moral fitness violation categories that they feel are present in today's case. The members are able to do one of three things: affirm the moral fitness violations, which would be accepting as is, as presented in the staff report; modify the moral fitness violations, so make changes, or negate, which would be removing all of the moral fitness violations that have been presented today. I would open that discussion up to the committee at this time.
Rob Wood for the record. I guess I would make a motion at this point to affirm the moral fitness violations as presented by staff.
And Member Dresser, I'll second that.
Thank you, Member Dresser.
All right, we are voting on a motion to affirm the moral fitness violations as presented. Committee Member Boren,
Aye.
Committee Member Dresser,
Aye.
Committee Member Griffin,
Aye.
and Committee Member Wood.
Aye.
Motion passed.
Now is the time to take another motion and second, I believe, on action to be taken from the moral fitness violations. Is that correct? Okay. I'll open that motion and discussion up to the committee.
Mark Bourne for the record, I move to take no action.
Rob Wood for the record. I'm going to oppose that, just to let you know, an open discussion that for consistency with other cases we've had on the PPC, I'm gonna make a motion or a counter motion that we do take action.
So we currently, this is Maria Atwood for the record, have a motion to take no action and a counter motion to take action. Do we have a second on either of those motions?
Rhonda Griffin, for the record, I second the no action.
Okay, so since we have a motion and a second for a no action, do we vote on that first? Okay, at that point, we will take a vote. Is there any further discussion, I should say, since we have two counter motions presented before the committee at this time?
Rob Wood, for the record, I'd like to just open discussion that taking action then follows up, if we do take action, with a period that could be, lack of better terms, already realized or time served. But I'm very concerned with consistency with prior cases of such aggravating situations post alcohol related incidents.
Thank you, Member Wood. This is Maria Atwood for the record. And in terms of, just for clarification's sake, for your comment about a time period being already realized. So for gross misconduct allegation, the time period of ineligibility would range from 0 days to up to 10 years. For a dishonesty allegation would be 0 days for up to 10 years. So just so that the committee members and Mr. Rios are aware of what those timeframes could look like.
And Robert, for the record, just for clarification, I think I already know this, that time starts as of the last conviction, the 2017 date.
Yes, the last criminal disposition, that's correct.
With that said, it's a little confusing here, but I would kind of go back and second Member Ward's thing that we do take action and we discuss, and for the reasons that he's already articulated, just the conduct itself, specifically the second event. I would agree with the consistency of past cases and stuff. This raises to that level based on the aggravating factors that we've already noted.
Mark Ward for the record.
Go ahead, Ms. Bourne.
Mark Ward for the record. I would just like to say that, I mean, I think I understand where you two are coming from, you know, being on the correction policy committee for a couple terms. I know that after being on this committee for a while now, this is starting my second term, it seems as though we've had cases like this in the past where we've had people with similar aggravating offenses, and you know, I think the mitigating outweighs the aggravating in this case, and in actually most cases that we see. You know, he's employed already. He's gone through a background check. He's gone through multiple layers of interviews, and he was employed by a state agency, and he has supporting documents from people that are working with him. And I would just make the case that I think that with his employment and that we take no actions.
It's Maria Atwood for the record. Any further discussion on either motion before we proceed to vote on these motions?
Rhonda Griffin for the record, and I just want to kind of back up or reaffirm what Mark had said, and that, you know, for me, it's been 7 years. While I don't agree with what he did, it's been 7 years. He's got somebody sitting behind him right now that is backing him. And I think that if anything further were to come of this, that it's on them for hiring him. I'm not sure we need to hold him accountable for something that happened 7 years ago. It appears that if he had a background, that he's not done anything like this since then, and he's learned from his past experiences.
Thank you, Member Griffin. If everyone would just stand by, I have a quick question for my colleague. Okay, thank you all for your patience. This is Marie Atwood for the record. I want to just kind of note for the committee members and for Mr. Rios what I just discussed with my colleague, Ms. Howe. So we are in a bit of a unique posture right now where there are 4, members present. There are 2 counter motions and what could end up being virtually a tie, right? If we vote on these motions as presented. In that circumstance, what I would ask the committee to do would be to continue discussion and deliberation today in the hopes that we could reach a majority vote on one of the motions. If the members, as is their right, feel pretty strongly about where they're at on their countervailing motions at this time, what we could do is essentially set this hearing over to continue at the next applicant review committee so that more members could be present to continue deliberations and vote again. That being said, as I was just reminded, if, for example, during today's hearing, the committee members continued deliberations and ultimately voted on a no action, there would still be a record of a moral fitness violation having occurred. And so if that is a concern of any of the committee members, that there would be no record of the discussion and determination that a moral fitness violation was present, that would still be part of this record, even if a no action vote were to sort of win the day today. So all that being said, I would reopen the discussion to committee members. If there is a majority that we can reach today, that's great. If the committee members are ready for a vote and all discussion has been exhausted, please just by way of thumbs up, let me know if you're ready to vote. We would first be voting on the motion for no action.
Rob Wood for the record. To the other 2 members that are leaning towards no action, we have a duty as committee members to recognize and protect the public. We also have individual positions on the PPC to us with all of aggravating circumstances. We would, in my opinion, definitely take action and assign a revocation period. In this case, it's not a revocation period. I can hypothetically put out on the table that I think the time that might be discussed if we take action would be far less than the time that's already passed. Yes, there would be a moral fitness violation on the record, but it would also show that the committee members took no action, which I think would be concerning. There, I said my piece.
Thank you, Roy.
Member Bourne, if you're attempting to speak, we can't hear you.
I'm not. I'm talking to my grandkids. Sorry about that. And listening at the same time and making their lunch. So I would say that I appreciate, the other members' comments. I just don't think that, adding, taking action and adding time that's already been served is going to change a whole lot. I mean, we've obviously noted the aggravating and the mitigating. I just don't see that would really serve a purpose here. If he was actually going to be penalized in some way, that would be one thing, which I still wouldn't be in favor for, but it really isn't going to serve a purpose, in my opinion.
Kevin Dresser for the record. Yeah, I think we're going to be split on this. I agree with Member Wood's assessment of this and the duties of the members of this. So while while the outcome is probably going to be the same, I think a vote of no action based on the severity of the, especially the latter incident, I can't support that. I agree at the end, either vote is going to likely not hinder his employment in the end, but I agree with the record being correct with regard to this membership in this committee.
This is Marie Atwood for the record. If there is no further discussion on either motion, Will the committee members show by way of thumbs up if you're prepared to vote on first the motion for no action and then if applicable, the motion for action? Is everyone ready? Okay, at this time, we have a motion and a second for taking no action. We will vote on that first.
Right, we are voting on a motion to take no action. Committee member Borton,
Aye.
committee member Dresser,
Nay.
committee member Griffin,
Aye.
and committee member Wood.
Nay.
Okay, motion has not passed because there is no majority, so that we are maintaining all the processes correctly. We will now vote on the motion to take action.
Okay, voting on a motion to take action. Committee member Warren,
Nay.
committee member Dresser,
Aye.
committee member Griffin,
Nay.
and committee member Wood.
Aye.
Motion failed.
Okay. This is Marie Atwood for the record. Seeing as how neither motion has passed through today's committee, I think really our only solution is to continue this hearing to the next committee meeting, which will be on what date? October 22nd, 2025, at which point we will hopefully have a few additional committee members present who can continue the deliberations and reach a majority vote on these currently, I suppose, pending or defeated countervailing motions. Are there any questions from committee members about today's processes or what's coming up next? I understand this is an unusual posture for us to find ourselves in.
I guess the question I have, would we have to necessarily start all over with review and affirming the moral fitness violations, or can we just start right with a vote?
That's a good question. My inclination is to say we would not have to start completely from scratch. This is Marie Atwood for the record. Is that accurate?
Jennifer Howell for the record. It feels as though if new members are allowed to participate, we would want to allow them to also participate in the aggravation and mitigation discussion. So I don't know if that means that we start at the beginning of the session and go through the whole process, or if we present what we have all done here today and then open back up the aggravation mitigation discussion.
Understood.
So that so those points can also be made to the decision of whether to take action or no action.
This is Marie Atwood for the record, kind of thinking out loud. I understand I think the spirit of fairness, I suppose, should allow the other committee members who would be present at the next hearing an opportunity to fully discuss the matter before voting. And I think that would also kind of then follow that Mr. Rios would have the option of appearing again and representing mitigation, or in the alternative, we can transcribe your mitigation from today and release that record to the committee members before next month. If you have questions about that, we can, Ms. Park can talk to you about that after the hearing is finished for today's purposes.
Okay.
Does that make sense to everyone? Are there any additional questions? I think we would start basically from the adoption of the record phase, unless Mr. Rios would like to present any additional mitigation.
Kevin Dresser for the record. I mean, if I was a member coming on to this October meeting, I would want to have the full advantage of what we as members had today. So I agree with Ms. Atwood's assessment of what we do in October.
Thank you, Member Dresser. Okay. With that, I don't believe there's any further processes or action we can take on Mr. Rios's case today. So again, thank you for being here. If you have any questions for Cindy, I guess, do you want to walk him out and see, or?
Yeah.
Okay.
Well, you want to wait in the lobby?
Yeah.
I'll just come out and talk to you when we're done. I just have one more thing.
Okay.
To go on, I'll let you go now.
They want, you to grab their badges.
Do they have?
Yep.
Yeah, they're going back to
They're
their.
going in, I can grab them. too.
Okay, don't forget. Submit your badge on reception. Thank you.
This is Marie Atwood for the record. Thank you to the committee members for the discussion. It's a very valuable discussion, I think, about Mr. Rios's case that we will continue to our next meeting. That brings us to item number 4 on the agenda, which is our inquiry closure memos that were also prepared and distributed to the committee by Ms. Park. I believe the inquiry closures only require a consensus vote. Is that correct?
They're just.
It's a non-voting.
There's some.
Oh, okay. And in that case, I will turn it over to Ms. Park.
TPSST completed 6 inquiry closure memos as a result of inquiries into pre-employment criminal conduct and detailed in the attached memos. Documents are provided to the committee for informational purposes only. This Oregon administrative rule has given DPSST authority to close these inquiries without committee approval. So.
Okay. Are there any questions or any discussion regarding the closure memos from the committee members? Okay, I think if there's no further discussion or points of clarification needed, that is the last agenda item we have for today. Agenda item number 5 notes when our next meeting will be, and that's October 22nd of 2025. Again, thank you to all of our committee members for being here today. Thank you to our team and Ms. Park for preparing the materials. Thank you to Juan for getting everybody all wrangled together this morning. And again, thank you, Member Dresser, for appearing with us at the last minute.
Thank you.